Hi everyone, this is Mengmeng, the co-author of the paper International Intellectual Property Protection under the RCEP Perspective. The article was finished by Zhaoxun, Li Qingting, Li Chunting, and Mengmeng. Now I'd like to introduce our research paper. This paper is divided into 4 parts. The first part is introduction, and the second part is analysis of the RCEP, TRIPS, and TPP frameworks. The third part is cross-sectional analysis of RCEP, TRIPS, and TPP IPR provisions, and the last part is cross-sectional analysis of RCEP and China's IPR provisions. The RCEP consists of a preamble, 20 chapters, and 4 annexes. In addition to initial provisions and the general definitions, the RCEP chapters not only provide for trade in goods, sanitary and phytosanitary, trade in services, electronic commerce, small and medium-sized enterprises, economic and technical cooperation, and government procurement, but also covers provisions on trade facilitation, intellectual property rights, competition, dispute settlement, and other rules. In addition, the RCEP includes 4 annexes, namely the Tariff Schedule of Commitments and the Schedule of Specific Commitments on Services, the Schedule of Commitments on Reservations and Incompatible Measures on Services and Investment, and the Schedule of Specific Commitments on the Temporary Movement of Natural Persons. In the case of the RCEP on intellectual property rights, it contains 14 subsections with 83 rules and 2 annexes on transitional arrangement and technical assistance. In terms of content, the RCEP covers a wide range of areas. This chapter is the longest and most comprehensive provision applicable to any FTA signed by China to date. The chapter covers not only traditional IPR protection such as copyright, trademarks, patents, designs, traditional knowledge and folklore, geographical indications, and genetic resources, but also broader areas of cooperation such as anti-unfair competition, IPR cooperation, enforcement, and technical assistance. This shows that while RCEP is actively exploring traditional IP protection topics, it is also constantly exploring new trends in IP protection. In terms of protection, the RCEP is more intense based on the TRIPS agreement. The RCEP strengthens the overall protection of IPRs in the region. In addition, it provides new ideas and strategies for the protection and the development of IPRs in the region by reorganizing the content of copyright rights, unifying the content of basic trademark protection, and strengthening the efficiency of patent examination procedures. The RCEP is more inclusive in terms of the main plan, and it respects the development differences of its member states, thus providing a more balanced IP development strategy to further promote the integration and sustainable development of IP in the region. A transitional period is set out in the IPR chapter of the RCEP. A transition period in the context of RCEP refers to a period of transition before a party fully implements the IPR chapter of RCEP. The transition period provision covers both the transition period for LDC parties and the transition period for specific parties. For example, 7 of the parties, Cambodia, Laos, Malaysia, Myanmar, the Philippines, Thailand, and Vietnam, apply transitional periods of 3, 5, 10, or 15 years differently in relevant areas. In general, the IPR provisions agreed in RCEP, TRIPS, and TPP have a high degree of similarity, and there are few differences in the structure and sequence of the chapters. While the general framework of RCEP, TRIPS, and TPP has a high degree of similarity, there are still differences in the details of the three. Firstly, RCEP does not have a specific section on the protection of undisclosed information and typographies in the substantive content of IPRS, whereas the TRIPS has a specific section on the protection of undisclosed information and typographies in its Part 2, and TPP also has a specific description of undisclosed experimental or other data. Secondly, RCEP and TRIPS both refer to unfair competition provisions or control of restrictive practices, which are not covered by the TPP. Thirdly, RCEP has a separate Section 7 on the protection of intellectual property rights in genetic resources, traditional knowledge, and folklore, which is not mentioned in TRIPS or TPP, and this is a feature that distinguishes RCEP from the other two agreements. Fourthly, in terms of enforcement, the TPP has a separate region for TRIPS, which is more detailed and extensive than the RCEP and TRIPS in terms of Internet IP protection. This shows that the RCEP focuses more on IP protection for developing countries, which is also highly consistent with the objectives of the RCEP as set out in its preamble. The preamble states that the purpose of the agreement is to build on the existing economic ties between the parties, to broaden and deepen regional economic integration and promote regional economic cooperation, to deepen the economic partnership between the parties, and to take into account the development gaps between the parties, and to apply the agreement flexibly, to consider the increased participation of the parties that are not developed countries in the agreement, and the effective implementation of their rights and obligations under the agreement. As most of the members of the agreement are developing countries, the content of the intellectual property chapter of the RCEP is naturally more inclined to protect and assist developing countries, which is also characteristic arising from the fact that most of the RCEP contracting parties are developing countries. In general, the RCEP maintains a high degree of consistency with TRIPS and TPP in most of its provisions. But this does not mean that the RCEP does not have its characteristics in its provisions. It is easy to see in the specific details that the RCEP has developed many new provisions to face the new circumstances resulting from current social, economic, and technological developments. For example, it addresses the issue of bad faith trademarks, the protection of satellite signals, the grace period for patents, and the protection of genetic resources, traditional knowledge, and folklore to regulate. In terms of enforcement and procedure, the issue of domain names in the anti-unfair competition regime and the enforcement of digital property rights in intellectual property. As the above shows, also the framework of RCEP is similar to that of TRIPS and TPP. There are more differences in the specific provisions and related regulations. As can be seen from the above listed differences, the new additions to RCEP are in line with current international trends in the development of IP in the region. Prior to joining the RCEP agreement, China had already laid out its IP legal system nationally, and during the period when the TRIPS agreement was active worldwide, China acceded to a cumulative total of 14 international treaties on IPRs. The legal system of intellectual property is, by its very nature, a public legal policy that combines the various areas of law that regulate intellectual output. The legal system itself is a means of balancing the rights of the various parties, which, when competing and developing within the framework of the legal system, inevitably result in a conflict of rights. In this case, it is necessary to moderate the rights of the parties so that the subjects within the framework of the legal system can obtain dynamic fairness to achieve maximum economic benefits. The legal system of intellectual property has a high social stickiness, and the rapid development of society will inevitably stimulate the legal system of intellectual property to develop by leaps and bounds. The RCEP IP chapter responds well to this pressure, as it is perfectly suited to the national circumstances of the RCEP sponsors, ASEAN countries, and the other partners of the agreement, achieving a dynamic harmony. In addition, the RCEP is more in line with the economic development mindset of developing countries than the TPP, and is bound to bring more benefits to the members of the agreement. Finally, the RCEP is more forward-looking in its intellectual property provisions, which makes it an important regional international agreement with a well-defined category, rich content, and complete planning, and its influence is immeasurable. China's legal system relating to intellectual property rights has been continuously improved and has gradually developed a distinctive legal system. However, in China, IPR related legislation has always existed as a special law of civil law, and there is no unified IPR code. Therefore, there is a lack of unified statutory law to guide civil judgment and criminal judgment when applying RCEP related content. China's accession to RCEP will not only further strengthen its various trade exchanges with ASEAN and promote further economic development in the East and the Southeast Asian region. But in terms of its national significance, the RCEP's IPR agreement is rich in content and is the most comprehensive IPR agreement that China has signed to date. It will also further stimulate China to make changes in its legal system by putting the legislation of the Intellectual Property Code on the agenda as soon as possible, and using the Civil Code as an opportunity to organically integrate the laws related to intellectual property rights, thus promoting the joint and harmonious development of China's intellectual property legal system and the civil law system. Thank you for watching.